Good afternoon, this is Martin Wragg. I'm a director of Edward Hans & Lewis Limited and manager of Buxton branch. My area of expertise is corporate and commercial work, including commercial property and contracts of all description. And I'm going to talk about shareholder agreements because their value is often not recognised by clients, and they can help avoid disputes or help a resolution if a dispute arises. It's not often understood that the company's constitution, comprised in its articles of association, forms the basis of a statutory contract between the shareholders and the company, and between the shareholders themselves. It is binding upon anyone who acquires shares and can be enforced by a shareholder if there is a breach of his rights as a shareholder. It cannot be set aside for misrepresentation or undue influence, and the court cannot imply any terms into it. However, it can be amended by a 75% majority of shareholders present and voting at a members' meeting, which renders vulnerable a minority shareholder. It's also the case that the articles are a public document and accordingly available for anyone to obtain a copy of from the Company's House. A shareholders' agreement, on the other hand, is a private document. It's a contract between the shareholders in a private limited company. It is intended to regulate the relationship between the shareholders. It may specify things which shareholders must do, and may specify things which they must not do. The company may also be a party to the agreement, which is particularly important if the intention is to bind the company to the provisions of any such agreement. The provisions of the agreement will be legally binding and enforceable by all parties to it. The primary purpose of a shareholders' agreement is to record the intention of the parties as regards the business. This is likely to include what the company can and cannot do and how it is to be managed. It is intended to protect and promote the business of the company and the joint interests of the shareholders. It is intended to supplement and underpin the constitution of the company contained in its articles. A shareholders' agreement will be advantageous wherever there is more than one shareholder in a private limited company. A company and its business will be at risk whenever the shareholders are unable to agree about matters of importance. These include issues about management of the company, financial management, share allotments and transfers, expansion or disposal of the business, and the acquisition of a new business. The interest of an individual shareholder may also be prejudiced by such disagreement. A decision to enter into a shareholders' agreement requires the shareholders to consider and plan for such contingencies, and the very act of recording their intentions assists shareholders to avoid disagreement. A shareholders' agreement can be entered into at any time in a company's existence. If a newly formed company is to have more than one shareholder, it is most advantageous to enter into a shareholders' agreement at the time the company is incorporated and before it starts to trade. If, however, a company only has one shareholder initially, but subsequently issues shares to one or more additional shareholders, then the agreement should be entered into at the time those shares are issued. If subsequent shares are issued to new participants, they should be required to enter into a deed of adherence by which they agree to comply with the terms of the shareholder agreement. The provisions of a shareholder agreement will be binding on each shareholder signatory for as long as that individual holds shares in the company, unless or until the agreement is terminated or the company is sold or becomes insolvent. The agreement can be varied or terminated by agreement between all parties to it. The agreement might provide for a variation by a majority of the shareholders rather than unanimity. But if a proposed variation is prejudicial to a non-consenting shareholder, it may not be binding on that individual. The Articles of a Company, together with the Companies Act 2006, set out a mechanism for management of the company and the operation of its business. These provide for decision-making to be undertaken by the Board of Directors. It may be that not all shareholders are directors, and even if they are, an individual may be outvoted by a majority of the directors. A shareholders' agreement enables the shareholders to exercise control over the way that the company's affairs are conducted by setting out obligations and entitlements of each and specifying what is to be done in specified circumstances. It may also provide protection to individual shareholders in a situation where they might otherwise be prejudiced. It is important that there is no conflict between the articles and the provisions of a shareholders' agreement. Because of the importance of the provisions of a shareholders' agreement as between the shareholders, it is common to settle the terms of the agreement before a new company is incorporated and to draft the articles by reference to the provisions of the agreement. When the members of an existing company wish to enter into an agreement, it is usually necessary to draw up new articles for adoption by the company at the time the agreement is executed. A shareholders' agreement will normally contain a clause to the effect that in the event of conflict between the articles and the provisions of the agreement will prevail. However, such a clause cannot be relied upon 100% in the event of an aggrieved member making application to the court and asserting unfair prejudice. If a shareholders' agreement requires unanimity on a particular matter and there is a dissenting minority shareholder, that individual could frustrate the wishes of the majority. Even where the agreement provides that a matter can be determined by a specified majority, a deadlock can still arise. It is therefore common to include provisions designed to encourage the amicable resolution of a dispute. It will be necessary to consider which disputes on which subjects will trigger the deadlock provisions, as well as the dispute resolution procedure. This could include referral to the holder of a golden share or to an expert or arbitrator. Alternatively, the members may rely upon provisions entitling a majority to purchase the shares of a minority, or giving a minority shareholder the right to require the majority to purchase his shares. A Russian roulette clause is the term used to describe a situation where a company only has two shareholders and enables one to serve a notice on the other offering to buy his shares at a stated price. The term arises because the other can either accept that offer or serve a binding counter notice to purchase the shares of the first at the same price. A Mexican shootout is the term used to describe a variation by which one shareholder serves a notice by which both shareholders have the opportunity to submit sealed competitive bids to buy the shares owned by the other. The adoption of different classes of shares can also be used to avoid disputes. There is no limit on the number of different share classes that can make up a company's share capital. This is necessarily set out in the articles, but a shareholders' agreement will usually contain complementary provisions. For example, A ordinary shares may entitle the holder to 1 vote per share, whilst B ordinary shares have enhanced voting rights, 2 or 3 or 10 votes per share, and conversely C ordinary shares could have none. There's no limit to the options that are available. Quite apart from the risk of disagreement between members, it is common for other events to occur which may lead a majority to decide that it is advantageous to acquire the holding of a minority shareholder, or indeed the other way around. Consider, for example, what should happen in the event of a member who dies, loses mental capacity, becomes insolvent, commits a serious criminal offence, or ceases to be a director or employee of the company. It may be desirable to include mandatory share sale provisions in some or all of these circumstances. It may also be considered beneficial to provide that the spouse or next of kin of a deceased member should have the right to require other members to purchase his shares. It will be unusual for a shareholders' agreement not to include provisions enabling or requiring shares to be transferred in specified circumstances. It is therefore important to include provisions for agreement or determination of the price, and a procedure by which a sale or purchase can be implemented and progressed to completion. Typically, there will be complementary provisions in both the agreement and the articles. The contents of a shareholders' agreement should be tailored to the particular requirements of the shareholders. Whilst some provisions will be included in the majority of shareholders' agreements in one form or another, others will be highly individual, and no 2 agreements will be identical. I've listed some of the more common provisions included in shareholders' agreements, and there are many options, so it isn't the case that any agreement will include all of these, but most agreements will include some of them. So, a requirement that certain decisions be approved by all shareholders or by a specified majority. A provision that a shareholder or a shareholder with a number of shares in excess of a specified threshold be entitled to a seat on the board of directors. Provisions that 1 or more specified directors be present if a board meeting is to be quorate. Of course, if there's an individual director who believes he's in a minority on a particular subject, he can dodge that meeting and render it inquorate. A right for a shareholder to require certain information to be made available. A dividend policy. It may be that 50% of net profits have to be distributed by way of dividend, or whatever the proportion is. Or it might say that all profits have to be retained and used to develop the company. Preemption rights over shares vested in another shareholder who wishes to dispose of them. So that might, for example, give other existing shareholders the right of first refusal. A right for a shareholder who wishes to dispose of shares to require another shareholder to purchase them. A right for a minority shareholder to join in a sale of shares by a majority shareholder on equal terms, commonly referred to as tag rights, as in tag along. Alternatively, a right for majority shareholders to require a minority shareholder to join in a sale of shares to a third party, known as drag rights, because most buyers of majority stakes probably want total control. A right for majority shareholders to purchase the shares of a minority shareholder. Compulsory transfer of shares in certain circumstances, e.g. death, loss of mental capacity, insolvency, or the resignation or dismissal of an individual as director or as an employee. There might also be restrictions on share transfers. That might be to the effect that as long as the individual remains a director, he has to have a qualifying shareholding, and therefore cannot transfer them. There might well be a restriction on altering the articles. It might require unanimity or a specified majority. The provision of business capital. That might be an obligation to contribute capital on an equal basis or on whatever basis in the event of the company needing additional funding. Or there might be a requirement that a shareholder cannot be required to contribute capital. There might well be provisions saying that there should be no borrowing by the company without unanimity, or restrictions on capital expenditure, no purchase in excess of a specified figure without unanimity, and similarly restrictions on disposal unless there's unanimity or a specified threshold of shareholders voting for it. There are likely to be restrictions on non-routine transactions, or a specified majority or unanimity required to make a decision to issue or defend legal proceedings, and similarly for authorization and material change in the nature of the company's business, or appointing or removing a director from the board may require unanimity or a specified majority. The remuneration of directors may have to be agreed by the shareholders, either unanimity or majority. There are likely to be confidentiality provisions as to the terms of the agreement. It's likely that there will also be covenants by shareholders not to participate in a competing business. And there may well be provision regarding ownership of intellectual property rights. Commonly, any rights accruing by virtue of the efforts of an individual vest in the company. And a key point, privacy. Whilst some of the foregoing provisions could be incorporated in the articles are a matter of public record. A shareholders' agreement is confidential to the parties, is not referenced in any public register, and it's not disclosable, save by order of the court, if the contract so provides. Invariably, a shareholders' agreement will contain covenants by the shareholders that are intended to be for the benefit of the business. It follows that they must also benefit the company. However, they will only be enforceable by the company if the company is a party to the shareholders' agreement. And it will not be appropriate for the company to be a party to the shareholders' agreement if the agreement contains provisions which have the effect of restricting the right of the company to exercise various powers which it is authorised to exercise pursuant to the Companies Act 2006. For example, the Act says that a company can amend its articles if a 75% majority of shareholders present and voting so determines. So the articles cannot contradict that, and the company cannot enter into a contract which prevents it from exercising its statutory powers. But the shareholders can, and that's where a shareholder agreement has a clear benefit. So in conclusion, the content of a shareholders' agreement will be informed by the requirements of the parties and the vision that they have for the development of the company. It can include any provisions that the shareholders agree to be beneficial. There's a freedom to contract, provided that that contract does not contravene the law. Compared to the modest cost of incorporation, a shareholders' agreement is an expensive exercise. It will be apparent that it can be a very complex document. However, if it enables disagreements between shareholders to be avoided or resolved, the cost incurred in entering into the agreement will have been an important and valuable investment. Moreover, it enables the shareholders to apply their energy to promoting the business of the company through an agreed strategy. The more successful the business, the greater the value of the investment. It's an unfortunate facet of human nature that success too often results in disagreement as the value of the business becomes greater, and that can have the effect of encouraging the parties to litigate. However, a shareholders' agreement usually has the opposite effect because the objectives are defined. Thank you for listening. If anybody has questions, I'll be very happy to take them, and my email address and phone number is on the screen.